Welcome to the Ethical Obligations and COVID-19, What Tax Practitioners Need to Know, sponsored by the ABA section of Taxation. If you are seeking CLE credit, you must attend the entire program. Partial credit is not available. Please click on all participation verification alerts during the program to confirm your attendance. Immediately after the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested. Once the completed form is submitted and your attendance verified, your certificate will be emailed to you. Moderating the program today is Nicholas Bonson. Nicholas, you may proceed with the program.
Thank you very much. Good day to you all, and thank you very much for joining us for today's presentation. I am Nicholas Bonson. I'm an associate at the law firm of Castellanetz and Fink, and it is my great privilege to be moderating today's program. The ABA has once again put together a very distinguished panel of experts, many of whom should be familiar to you if you have participated in previous ABA programs. Our program today will cover, of course, the topic of ethics in the age of COVID-19, and it will run about 75 minutes before we open up the floor to questions. So without further ado, I'd like to introduce today's panelists. First, we have Judge Ron Buch of the United States Tax Court. Judge Buch has been serving on the tax court since January of 2013, having been nominated by President Obama to the seat vacated by Judge Laro in 2011. Thank you for joining us, Judge Buch. Second, we have Kathy Enstrom, who is the special agent in charge of the IRS CI's Chicago field office. In that role, she supervises approximately 175 IRS CI employees, and the geographic reach of her division covers the states of Illinois, Indiana, Wisconsin, and Montana. Minnesota. Next, we have Pamela Fuller, who is a senior technician reviewer in the IRS Office of Chief Counsel's Procedure and Administration Division. She is responsible for supervising other chief counsel attorneys. Their office, of course, deals with ethical issues, and she is responsible in part for supervising procedure and administration attorneys who participate in the tax court litigation program. Next, we are joined by Guinevere Moore, who is the managing member of Moore Tax Law Group, LLC in Chicago. Gwen is also the chair of the Standards Committee for the ABA section of taxation. She is a highly experienced practitioner, appearing regularly before the IRS and tax court on a variety of matters. Next, we are joined by Matt Cooper, another regular here on the speaking circuit. He is the managing director of Deloitte's Federal Tax Controversy Group. Prior to that, he served with the IRS Office of Chief Counsel's Procedure and Administrative Division for nearly a decade. Welcome to everybody. Thank you so much for joining us. And I will turn now to getting us fully underway. So today's program, as we indicated, is going to highlight some of the unique challenges to practicing largely from home in the age of COVID, and how that impacts, our obligations to comply with rules of professional ethics, which of course don't go anywhere. At the end of today's program, we hope you will have a better understanding of what those obligations are, and more specifically, how they are implicated by the new, shape of our practice on a daily basis. We hope you will also take away some practical and ethical solutions to resolving any issues that may arise in your practice, including things to be on the lookout for with respect to the CARES Act, scams that may be out there, and how to avoid participating in or to counsel your clients to avoid participating in any such scams. And also topics such as meeting deadlines with the, again, unique challenges of practicing from home. So I'd like to turn it now to Judge Buch, who is going to provide us with an update on the tax court and some developments there that I think will be of great interest to everybody here. So Judge Buch, please take it away.
Okay. Well, a little background about where we are at the tax court in the era of coronavirus. The last regularly conducted sessions of the tax court occurred way back on March 9th, and it was during that week that the court issued a release announcing that it was canceling the sessions for the beginning in the range of March 16th through April 3rd, and that began what is a series of announcements canceling our trial sessions ultimately through the remainder of that winter term and at this point up through the entirety of the spring term. So all of the trial sessions all the way through and up to through the end of June were all canceled. And then on about March 18th, we issued a press release announcing that the tax court building was closing. In addition to, a highly communicable disease, in addition to the concerns of bringing into a courtroom out in the field a large group of, IRS lawyers and taxpayers' lawyers and pro se taxpayers and all of the people that come into a courtroom, we also have the issues of transmitting it within the tax court and, of course, with processing all of the paper that we receive in the tax court. So the court's building was closed on March 18th, and as that press release noted at the time, that closing the building also meant that mail would not be received in the building. And again, as that noted at the time, that we would be having our mail held by the United States Postal Service for that mail that is delivered by the post, or that was sent through the Postal Service. Mail sent through private delivery services, designated delivery services, they don't hold it for us, and so that mail generally is being returned to the people who sent it, and I'll get more into that in a moment. Most recently, in the string of announcements, so as I said, we've canceled all of our trial sessions that had been scheduled up through the end of June. And then the most recent announcement, which I'll get into more in a moment, is Administrative Order 2020-02, which in short announced that the trial sessions in the fall would be handled remotely. And again, I'll talk more about that in a minute. The IRS Office of Chief Counsel issued a notice that under their statutory authority, they extended petition deadlines for where due dates fell April 1, 2020 through July 15, 2020. Those deadlines are all extended up to July 15, 2020. Now, an astute observer and somebody listening to my remarks just now might be thinking to themselves, well, wait a minute, didn't you say the building closed on or about March 18th and this notice was issued effective April 1? This is causing me some heartburn. What do I do about that? And so this is one of those items where I said I'd get to more of that in a moment. And so let's talk about mail and handling of things that the court have been sent to the court and that the court will be receiving. As I mentioned, mail sent to the court is being held until the court reopens. Mail sent by private delivery service, it is our understanding, is all being returned as undeliverable. And without opining on how any of these rules are going to hit a particular item, I guess what I would comment if I were in a practitioner's shoes is I would look at and think about a case by the name of Geralnik. Now, Geralnik dealt with a situation where the clerk's office was inaccessible or unavailable, and as a result, the petition filing deadline was extended. I believe that dealt with a snow shutdown in D.C. Some things to think about if you're thinking about, well, what do I do about something, a petition that may have been mailed, whether through a designated delivery service or the postal service? What are the things that I would want to think about? There is a statutory timely mailing is timely filing rule. There's an awful lot of case law out there on the timely mailing is timely filing. Things about sending things by certified mail, retaining postmarks, the control of postmarks. And if something were returned to me as undeliverable, for example, one of the critical things I think might be important if I were trying to convince the court that I truly filed my petition in a timely manner, even though it was returned to me, would be the original postmark on the original package that was sent. So, if something is returned as undeliverable, if you want to best preserve your argument, I would say retain whatever postmarks and whatever proofs of mailing you have. And because those will be issues that I think the court is going to have to face and is going to have to grapple with for that window of March 18th through April 1st. Now, what about the fall? We've talked about mail. Actually, let me back up on mail for just a second. The court will be at some point. We have not yet. We haven't announced a date yet. At some point, the court will begin processing mail again. And when the court does resume processing mail, if there is a petition to be mailed in, my suggestion is mail it in at the earliest opportunity. Indeed, mail it in now through the United States Postal Service with proof of mailing. That's going to be held. That was in our original release. And so, again, using the United States Postal Service is probably one of the safest routes at this point because we do know that mail is going to be held. So
and Judge Buch,
I
would just note, sorry, Judge Buch, I'm sorry to interrupt. I was just going to note before you turn on to the fall that the IRS website has a frequently asked question, at least from the IRS position, about Notice 2020-23 and how it operates with Guralnick. So if anyone's interested in at least the IRS's informal position on an FAQ, you should look to their website. But I apologize for interrupting.
Nope, thank you, and that's great to add.
Sorry, Judge, one more quick interruption, if I may here. Do you actually have a sense of the volume of mail that is awaiting the court when it is able to process?
I have heard rumor of a truck and a half. So and when I say a truck, I don't mean an 18-wheeler, but it is substantial. It took us, you might recall, a year ago there was a lapse in funding that resulted in a temporary shutdown at the court, and it took some number of weeks of people really putting in a monumental effort to get us caught back up from that. Here, we haven't been processing mail for months. So it will be an extended effort for the court to get caught up on the mail. But it is substantial. I mean, you can think of it in this perspective, and I know the IRS slowed down on issuing notices of deficiency, but if we receive somewhere in the neighborhood, I'm just going to make the math easy, of 24,000 petitions a year, that's 2,000 a month if we sort of spread it out evenly, and we've got April, May, and June, 3 months of held mail at this point. So that is substantial, and that number that I just ballparked only includes petitions. Keep in mind that the vast majority of our petitioners are pro se, and I believe the majority of them receive and make paper service, so things that they would be filing would be filed in paper. So it is a substantial amount that the court will be receiving, and it'll be a monumental effort for the court to get caught back up. Turning to the fall trial calendar, that was announcement 2020-02, which just came out this past Friday. And I suppose, and right there, the first item on that slide is perhaps the most notable thing, and that is there will be a fall trial calendar. However, there's going to be travel limitations. The court will not be traveling for its fall trial calendar. What the court will be doing is it will be conducting remote calendar calls and to the extent trials are necessary, remote trials. So let me chat a little bit about that. One thing I would note is it is a practice of many of our judges to manage a docket by conference calls in advance of a trial session. What usually happens is a couple of weeks in advance of a trial session, we get pretrial memos, and those pretrial memos really serve as a gauge for us of what cases need our attention. And many of us will begin to hold conference calls on those cases where a trial is either definite or probable in an effort to assist the parties in either narrowing issues, maybe resolving a case, or giving some guidance to help get the case best prepared for a trial session. I think one of the things that you are likely to see as a result of going to remote calendar calls is an increased use of the calendar calls, of the conference calls in advance of a trial session as a means to help narrow down the cases that need to be called at a calendar call. In fact, I think one of the things that can be done through those conference calls, just thinking of it from my own perspective as I try to manage a calendar, will be to take things off of the calendar call altogether. And if a case is going to need to have a trial, use those conference calls, the informal conference calls, as the time to help get the parties ready for what eventually may well be a remote trial. Administrative Order 2020-02, which, as I said, is on the tax court's website, includes a number of documents with it, a sample notice setting the case for trial, a sample standing pretrial order. There are some things in there that you'll see are different. For example, requesting that the parties submit the stipulation to the court 14 days in advance of a trial session, and include in that stipulation, the documents to be used at a trial. To the extent that exhibits can't be agreed to by the parties, those exhibits can be submitted to the court as unagreed exhibits, but submitted electronically in advance, which is important because if you think about, if you've been to a calendar call or been to a tax court trial session, it happens all the time where a petitioner is there, or whether represented or not, but it's frequent that documents show up for the first time either at the calendar call or very shortly before. If we're talking about remote hearings, remote calendar calls, remote trials, there has to be a means by which to get the documents in everybody's hands sometime in advance of that session, because you can't electronically share things spur of the moment the way you might, the way a judge might have the trial clerk go in back and make some photocopies at the session isn't something that's going to be able to happen live during an electronic case. So those are just some of the items that I would say take note of as you skim through the sample standing pretrial order. I think having a pretrial memo is going to be particularly important. The Office of Chief Counsel submits them in most cases where they think there is a chance that the case is going to go to trial. I'll, from my own perspective, and I'm ballparking this, but maybe for every 10 pretrial memos I get for respondent, I might get one from a petitioner or a petitioner's counsel. So I think pretrial memos are going to be important if you want to have the judge well informed on your case. I would look at pretrial memos as a way to do that. How are we going to be doing these? Again, the information is in the administrative order, but we will be using ZoomGov, which is it's an offshoot of Zoom that is FedRAMP certified. It's secure, and it also has the benefit of being one of the more user-friendly means by which to communicate out there. Keep in mind that most of the people who appear in our court, or at least most of the petitioners who appear in our court, do so pro se, and so it is important that we have a tool that is user-friendly, and we sampled many, and we found ZoomGov to be a very user-friendly option. And again, so how is the calendar call going to operate? My expectation is, for many of us at least, we will narrow things down substantially by having conference calls, and really the calendar call will probably be reduced to those cases where we haven't been able, for whatever reason, to have a conference call to either get a clear status of the case or to separately schedule a specific trial. So the fall is going to look very different from how calendar calls have worked in the past. You're going to start seeing at some point in the not too distant future notices of trial coming out, and we'll see trial sessions scheduled beginning in probably mid to late September, and continuing in the time of a fairly typical fall term. You'll see an item on here that says copy request. It's not really part specific to the fall trial calendar, but with the court building shut down, one of the consequences of that is when the court gets requests for copies, we can't process them if we aren't in the building. People often comment about their efforts to obtain records from the tax court. We do not broadly make our electronic publicly available. There was some articles out there about a lengthy presentation I did at the ABA back in January about the reasons for that, and the amount of taxpayer data in there that we have concerns about. So in the past, people have had to come into the building to request copies of documents or send someone to the building. So we have a recent announcement, because the building's closed and nobody can come in and request documents. It's led to some, I think, very helpful changes. I hope well received. The court will take copy requests via phone. The court's announcement, again, it's on the court's website, has the information on how that's done. The request once made, the court will pull the documents and set up the pay mechanism through pay.gov. Pay.gov, by the way, is how copy requests have been paid for in the past. That's no change. But probably the biggest change is that we will fulfill those requests by emailing an electronic copy of the requested document to the person who made the request. And then also another big change is the fees. Because there are certainly costs to the court, labor, et cetera, in getting documents out, but the labor doesn't vary dramatically based on the length of the document. So we've capped the current 50-cent per page change remains the same, but that we've capped it at $3 per document. So it's not the fees have been cut dramatically. I do want to address a question that came in about how we'll be able to use clinics. One of the reasons we chose Zoom.gov, and other services have this available as well, but there is the ability to have breakout rooms so that people can have conversations without having the judge involved. So there will be a lot more details on this as the calendar calls get closer, and we provide information on how exactly these proceedings are going to happen. So there are some things still being developed, but we do fully anticipate having the opportunity for people to get assistance from those who provide pro bono services. And then speaking from my own perspective, one of the things that I do on the conference calls that I described previously is if I'm having a conference call with an unrepresented taxpayer, it is common for me to provide the clinic information that we include when somebody first files their petition. I know we include it at several steps along the way, but if there's somebody who could be in use of assistance from a pro bono clinic, it's my practice to provide that information during those conference calls I have as well, so people can reach out. And then the last thing I'd mention, this is not directly related to the COVID-19 pandemic, but there's been some talk over some time about the court's development of a new case management system. And we anticipate that the new case management system will roll out this year. One of the things that will be particularly beneficial, especially if there's another circumstance like the one we currently have, is the new case management system will have the ability to file an electronic petition. So whether somebody is pro se or if it is through counsel, somebody will be able to go into the system and generate their own petition and file that petition electronically. What does that mean for Guralnik? Certainly, I'm not going to opine on anything, but when we look at things like the availability of the clerk's office, I think we would have to look at rules such as the timely mailing is timely filing rule. If somebody files a timely electronic petition, I don't think you have to worry about issues of the availability of the clerk's office if the petition is timely. I think that the question there is, well, what happens if for some reason the system is down? There is a statutory safe harbor of timely mailing is timely filing, but that requires mailing. So I don't think Guralnik is rendered dead letter by a case management system that goes live. So the hope is
Your Honor,
that system rolls out by the.
Pardon me. May I just clarify that pro se petitioners and even any other petitioner would still be able to mail in a paper copy of a petition even with the availability of an electronic e-filing petition system?
Absolutely. Our rules do require that practitioners be registered for e-file for e-access, and that'll continue with the new system. A petition can be filed electronically, again, whether by practitioner or by a petitioner. However, a practitioner will automatically be set up into e-access, and that's how practitioners will get served on documents from the court. And a petitioner who e-files a petition will then be in the e-access system. But if somebody chooses to do it by paper, they are free to certainly, if a pro se person chooses to do it by paper, they are free to do so. If a practitioner chooses to do it by paper, they are free to do so. They will, however, get electronic service of everything once the case is initiated.
Thank you.
And I think that covers what I had to cover about things happening at the court.
Great, thank you very much, Judge. So at this point, I'd like to turn now to Kathy for an update from the IRS CI perspective. I think there's quite a bit going on in your neck of the woods with the CARES Act and some of the programs under the CARES Act. I was wondering if you might be able to give us an update from your end, please.
Absolutely. Thank you so much. So the first question that's on the slide in front of you talks about returning erroneous payments. And I will direct you back to the irs.gov website in regards to this. But in essence, if it's a paper check, to write void on it and to mail it back to the IRS. And it's you have to mail it back to a service center that is specific to the state that the person lives in. And so that's why I'm asking you to go to the irs.gov website and check that out. It's the same thing as if it was a direct deposit. We're just asking for the individual to submit a personal check back and send it to the IRS location that's appropriate to them. So that was a quick answer to that first question, but I'm going to focus a little bit on fraud in the current pandemic environment. And we'll go through a couple of scenarios. I'll talk about some things that you need to look out for, and then some of the cases that we have been working on nationwide. So first, obviously basic refund fraud. We're actively pursuing potential ID theft leads where multiple economic impact payment checks or EIP checks are going to the same address. These are being identified in collaboration with IRS Civil and our partnership with the U.S. Postal Inspection Service. And we're identifying quite a few leads out there nationwide where multiple checks, and when I say multiple, possibly for one example is 100 checks going to the same address. And we're doing investigative work behind that. We've also received a few leads from around the country that relates to Form 8888 fraud, which is allocation of payment. So this is similar to cases that we've worked in the past where a tax preparer files the Form 8888 and tells the taxpayer, I'm going to receive your refund, and then I can give you the money after the refund comes in. And they may or may not provide the entire refund over to the taxpayer. Well, in these particular instances, it's extending to the EIP payments, where if a Form 8888 was filed, the IRS did send back via direct deposit or check to the person on the line 1 of that Form 8888, which in some cases was the return preparer. And sometimes they were very ethical and good return preparers, and sometimes they were not. And so IRS Criminal Investigation did do a lot of work in that space, identifying the misuse or abuse of that Form 8888 and too many checks going back to the preparer. And moving into the mail fraud aspect, there is obviously massive concern about when the checks went out, would they be stolen from the homes? Unfortunately, in my territory of Indiana, in Indianapolis, about a month ago, a mail carrier was shot by an individual because that individual was waiting for his EIP check and they didn't have it yet. And so that's quite an extreme example, but we are looking at everything in regards to that mail theft as well as stealing return information or returns or refunds from other people. And then finally, the prepaid access cards. Recently, the Bureau of Fiscal Services sent out over 2 million cards that estimated about $3.7 billion. And so, of course, with that amount of money comes potential fraud. And so in regards to that, again, theft of those cards from mail drop locations, and sometimes even theft in the regards to maybe a person, they knew that person was getting a prepaid access card and notified them, hey, call this number to activate your prepaid access card. And unfortunately, it wasn't a legitimate number, and the victim on the other end of the phone gave over all of their personally identifiable information to a fraudster. And so we're on the lookout for that as well, and we'll be investigating anything along with our partners in TIGTA and the other federal law enforcement agencies. Moving into the other COVID-related scams, quite a bit of cases that we've been seeing in regards to the organized selling of medical supplies, and that's extremely sad in this time and day and age with the lack of having the appropriate personal protection equipment out there. A lot of fraudsters are out there trying to make money from that. And so back in April, on the 27th in Brooklyn, 2 individuals were arrested for purporting to sell over $4 million of PPE that they did not own and they did not have authorization to sell. They created a website, and on the website it said they've been in business for 6 years and selling it internationally. And they reinforced their claims that they had the inventory to sell. They displayed sealed and shrink-wrapped empty boxes in their office, which they stated were filled with masks. They also displayed to an individual who was posing as a representative of an investor that there were over 1 million masks were owned by an unrelated third party. So unfortunately for the bad guys, not only the individual they were trying to sell to as an investor was a federal agent, but also the people that said that they had the masks were federal agents. And so they were acting as a conduit. Another case example, one day later, right in the same neck of the woods, Brooklyn, 2 more individuals were charged with price gouging. They were seeking to sell over 1 million masks in New York City at double or triple the purchase price. And again, this case was uncovered and eventually indicted by the use of undercover federal agents. And then one more case example that's much more recent. About a week ago, on the 26th of May, a licensed pharmacist was arrested for hoarding and price gouging of N95 masks and making a false statement to law enforcement, healthcare fraud, and aggravated identity theft. He purchased over 200,000 masks in early parts of the pandemic. Federal agents went to him and said, hey, if you have this many in masks, you can't gouge, you can't hoard, all of those things. He said he understood everything. 2 weeks later, after the federal agents had paid him a visit, he continued to purchase more masks and sell them at an inflated price. In one instance, he sold one mask for $25. So we ended up arresting him on May 26th in the New York area. So those are some examples of things that IRS-CI has been working on along with our colleagues at the FBI and the other federal law enforcement agencies. Also on the lookout are testing scams where people are selling fake at-home test kits, treatment scams, selling fake cures, charity scams. That's always been an issue whenever there's some sort of event that causes for uptick of charity. Investment scams, and then unemployment fraud. So we are seeing an uptick where criminals are coordinating a mass-scale attack by creating accounts under the freefilefillableforms.com website associated with the CARES Act and on state unemployment websites. And this probably using stolen identities provided, probably obtained via the dark web, and signing up for unemployment. So we're working that angle as well. I will say that we are coordinating very well both internally within the IRS and criminal investigation, as well as our external stakeholders. Our cybercrime section is working with TIGTA, HSI, and DOJ regarding IP address spoofing, fraudulent use and hacking attempts to the non-filer portal, and all the organized criminal cyber rings using COVID to perpetrate fraud, phishing attempts, and buying and selling of PII in the dark web. Externally, we're also partnering with our U.S. attorneys' offices across the country, as exampled by the cases I explained a little earlier. And because it's a global problem, it requires also a global solution. And so that's why IRS is working with the Joint Chiefs of Global Tax Enforcement, known as the J5. These 5 countries come together and work together on tax fraud internationally. Those countries are, of course, the United States, Australia, Canada, the UK, and the Netherlands. And we've had a lot of success on that front. And then finally, I wanted to talk a little bit more about the COVID financial aid fraud, and more specifically about the PPP loans that SBA is sending out. So we're seeing, obviously, claims made by criminals using fictitious businesses, misrepresenting the existence of business expenses or the true financial impact from COVID. And some of these are very legitimate, and that's the great thing about the CARES Act is we're providing help toward those businesses, but there have been a few that are completely fictitious. So on May 5th, we had the first in the country charges against 2 individuals in Rhode Island. They allegedly filed bank loans, applications seeking more than $500,000 in the PPP loans. They claimed to have dozens of employees at 4 different restaurants. In fact, no one worked for them. It's about $500,000 that they requested the loan for, and they were charged with conspiracy to make false statements and conspiracy to commit bank fraud. One of them is also charged with aggravated ID theft. And then a little more recently, on May 21st in New York, a Chinese national residing in Manhattan was arrested for a scheme to obtain $20 million in PPP loans. He falsely represented to the SBA and 5 financial institutions that his companies had hundreds of employees when in fact he was the only employee. He also fraudulently represented that he was representing New York State in procuring COVID test kits and PPE, which in fact he was not. And then very recently on May 29th, just a few days ago, in Norfolk, Virginia, a man also was charged with fraudulent loan application and disbursements of over $190,000. Within a few days of receiving that $190,000, he converted the money to cash and cashier's checks and was charged with several felonies, including money laundering, wire fraud, and theft of government funds. So I just wanted to wrap up a little bit with the takeaway for me is that COVID is just like any other natural disaster in terms of criminals preying on victims. The only difference is the breadth of this disaster reaches everyone in the country and, as stated before, everyone in the world. Criminals are trying to take advantage of our most vulnerable times and our most vulnerable populations. But because we've seen these schemes before in IRS-CI, we know how to find them, we know how to expose them, and we are prepared and equipped to do just that. So I look forward to our conversation a little bit later. Thank you.
Thank you so much, Kathy. And with that, I would like to turn to Pam Fuller to give us a little update on how the Chief Counsel's Office is adapting to the world in which we find ourselves these days. Pam?
Thanks, Nick. The first thing I want to do is, again, give a plug to the IRS.gov website. The IRS has created a special site that provides the latest information and guidance about the coronavirus tax relief and also economic impact payments. You can access it through irs.gov and look for coronavirus relief link, or you can type in the URL address directly. And that should be up on your screen right now. The website includes lots of information, especially information regarding extended deadlines. Judge Buch mentioned earlier RevProc 2020-23, which extends, notice 2020-23, which postpones certain deadlines for tax court filing, but it also talks about extending or postponing the deadlines for claims for filing credits or relief of any tax, or bringing suit for claims for credit or refund or any tax. And it also mentions that all of the acts reflected in RevProc 2018-58 should be looked at as well in terms of being postponed. So the website includes a wealth of information. I encourage you to, if you can, bookmark it, include it as one of your favorites. The service updates it on a regular basis because, in this era, times, things are constantly changing. As far as Chief Counsel, our current state of affairs is that we are proceeding as usual. It's business as usual. We are meeting with taxpayers to the extent that we can. We are even having meetings in terms of private letter rulings and normal conferences. And one great thing that happened was that RevProc 2029 was issued. It modifies RevProc 2020-1 and temporarily allows electronic submissions of requests for letter rulings and closing agreements, and also information letters that are under Chief Counsel's jurisdiction. Also, it allows the electronic submission of determination letters that are issued by LBI. So the guidance provides special rules for how you will transmit that information to Chief Counsel. And the key is that it has to be transmitted by fax or compressed and encrypted using an email attachment. And also, it talks about the signature requirements and how you do need to acknowledge that there is a risk when you're using compressed email. But again, all of that information on the specifics is included in irs.gov. Another thing that the service is doing is providing more flexibility with respect to signatures. The IRS issued a notice to its employees indicating that to the extent possible that the service will be accepting signatures on documents that are digital or a photocopy of a signature. So that is another important development. The breaking news for today is that there was a notice that was issued, and it talks about tax court, Chief Counsel and tax court cases, and the IRS Chief Counsel is going virtual, with national settlement days. So that should help many taxpayers settle their tax court cases, and we look forward to that happening.
And Pam, I understand you may not have the information yet, but can people expect to find more information on the IRS website when it's available in terms of, how they may participate, what facility they may need to set up in order to participate?
Yes, the more information will be forthcoming, and I know I personally will be encouraging that to be posted on the web. As you know, Chief Counsel is the other participant in these settlement days, so it's important that everybody, have the information. I can just tell you anecdotally that I have spoken to some colleagues that have participated in it in other offices, and they thought it has gone very well.
Yeah, and I would just echo what Pam said and say that, the guidance and the informal documents that Pam mentioned have been very helpful to practitioners, RepRoc 2020-29 and the Deputy Commissioner memo. I would just note that the Deputy Commissioner memo is really limited to signatures in what I call the controversy context, exam, or collection. The memo expressly states that it's not applying to signatures in the tax return context. So that's something that people need to be aware of. The ABA tax section has submitted comments to the IRS asking for additional signature guidance in the return context. And I think the AICPA is also working on similar comments. So there might be more in the future. And also yesterday there was a guidance document from the IRS making it easier for taxpayers to make elections with respect to retirement plans because of COVID-19. So again, that's a good outcome.
If you are working with somebody from Chief Counsel and you have their phone number, do know that we are working on your cases to the extent that you have submitted a private letter ruling or pre-submission conference request. We are working on it. We're considering the questions that you have. We are doing it in a different environment. So if you submit paper, it does make it a little bit more challenging for us. So that is one of the great things about the change in the RepRoc. But I would say that if you have somebody that we're working with, please do reach out, and they'll try to assist you in any way they can to help make this a more smooth process and answer your questions.
Okay. Well, with that, let's pivot a little bit now to some of the more ethical obligation-oriented components of today's presentation. And I think it's always helpful before we run through some hypothetical situations here that have been hopefully tailored appropriately to the world in which we find ourselves now. But I think it's helpful to always review just all of the sources of law that may touch upon what our obligations are, where they come from, and just the range of things that we have to keep in mind as practitioners at any level here, so that we can continue providing good service to our clients and also uphold our obligations to the profession here. And of course, the model rules of professional conduct put out by the ABA, and they are, of course, interpreted with a variety of comments and plenty of literature out there. There are formal opinions that are issued occasionally. Of course, the individual licensing jurisdictions for all attorneys have their own sets of rules and, of course, interpretations thereon. Don't forget Circular 230 for anybody who is practicing before the IRS at any level. There are, of course, provisions baked into the Internal Revenue Code and other just substantive laws out there that may impact or mandate a particular course of action in your practice. And again, the AICPA has its own rules governing the conduct of its members as well. So let me turn now to the first hypo that we've had today for you today. And without reading it all, the practitioner, we'll call him Harry for now, is an associate at a large firm, and he is finding himself in a very, very challenging and stressful environment at home, but one that I doubt is actually all that uncommon for people these days. And of course, he's doing the best he can to manage his practice and his responsibilities at home and the lack of any break between the two. And he does just fine for a number of weeks, but then eventually, as might be expected, he has a little accident and he misses a filing deadline and doesn't even realize it until a few days later, and then he tries to fix it real quickly. Seems like he botches that a little bit as well. So he finds himself having, tried to correct it, and then is all set to inform the client, but then, of course, circumstances intervene and he does not, and we get to a point a few weeks later on where he still hasn't informed the client. Quinn and Matt, do you want to discuss a little bit about what might be wrong here?
Thanks, Nick. Yes, this practitioner is certainly somebody who we have a lot of sympathy for, but I think the important thing is to take a couple steps back, like a couple weeks back, and thinking about, as practitioners, as we are all trying to balance changing work and family obligations, especially in light of the lack of reliable and safe outside the home child care. It's difficult to manage work and family obligations at the same time. And as anybody who is managing, caring for aging parents will tell you, that's a whole different level of difficulty. And so to me, the first thing that this lawyer should be thinking about, I'm going to go back because I'm looking for the exact rule here. Rule 1.3, comment 2. A lawyer's workload must be controlled so that each matter can be handled competently. And this is something that we all need to ask ourselves all of the time. Do we have the capacity to take on this additional new matter? It's a thing that we struggle to manage in the best of times, let alone in these crazy times that we're living in. But any time that a new matter is pitched, even if you think a big case is going to settle, things like that, it's important to think about whether you as a person are able to take on this additional work in light of your other workload. And in this time in particular, knowing that our obligations at home are often staggeringly greater than in normal times, do we really have the ability to take on extra work? And do we have the ability to service the clients who we are already servicing? Can we do that? And can we fulfill our obligations? So if we want to think about how, as practitioners, we can avoid this problem, I would encourage everybody to read Rule 1.3, Comment 2, and really think about, is it time to bring in co-counsel? Is it time to tell a client that you can't take that new matter in light of all of the other obligations that we have? But going back to the hypo, what is this practitioner going to do? How bad is it? It's terrible. The practitioner has an obligation to tell the client immediately that the deadline was missed, and the practitioner should notify his or her insurer immediately that this deadline was missed, and absolutely, unequivocally own up to the mistake. I think Kathy may disagree that the cover-up is worse than the crime, but the cover-up is certainly just as bad as the crime, and the longer that this practitioner waits to tell the client the truth, the worse it's going to be, because any remedial measures are going to be harder and harder to be effective. So this client has a bad malpractice problem, needs to notify the client immediately, and needs to notify his or her malpractice insurer.
Can I just chime in for a moment on the I'm sorry, can I just chime in for a moment on the unredacted client Social Security number? So I'm going to assume for this purpose that this is something filed with the tax court. And since I mentioned unredacted Social Security numbers earlier, I figured I would add a couple of thoughts here. One, this is one of the reasons that as I said earlier, we don't make taxpayer case records just openly and easily accessible online because they could be scraped for information like this. And it is not just because of the pro ses. When we did a statistical sample, we found that about 75% of our cases in which taxpayers were represented by private practitioners, there were unredacted Social Security numbers in the case files. So noncompliance is rampant in the tax court. What do you do if you discover that you filed something with the court that has an unredacted Social Security number? Number one, don't rely on the notion that the court isn't going to release the document. We aren't in the business of looking for unredacted Social Security numbers and protecting those documents. If a copy request comes in, we fulfill the copy request. So it is entirely possible that a document like that could get released. So what do? One, you file a motion to seal that document, or you file a motion to substitute a document. Now, if you substitute a document as a practical matter, what happens is the document that was originally filed, it stays in the court's record, but it is in effect sealed. And you substitute the properly redacted document. So that is the unredacted Social Security number is an item that can be cured, can be fixed, but you need, take prompt action and seek to have a replacement document put in the court's record.
Thanks, Judge. Quick question to Gwen, but to anybody here. Does it matter that the practitioner here tried to fix it before reaching out to the client, or would you say that the client was fine to be I mean, of course, the client should have been notified, but was the client fine to have been notified, after the practitioner here had gone ahead and filed, albeit late?
In my opinion, having the practitioner try to fix it without notifying the client makes it worse, because the practitioner did not give the client, didn't communicate honestly with the client, and didn't give the client the opportunity to decide whether that client wanted to continue with the practitioner in light of all of the other things that led to the missed deadline in the first place.
Yeah, and I agree. And we don't specify what the filing deadline was, but obviously the facts matter. But if it's some type of jurisdictional item, it might be a lot bigger deal, or if it's something that can be fixed with going to the court. But either way, I think they have an ethical obligation to let the client know and decide if the client wants to continue with this practitioner. I agree with everything else that Gwen said. The other point I would note is that we do say this is an associate at a large law firm, so it does beg the question of where is the partner or whoever, or the senior associate who is supervising this associate. There's obviously a duty to supervise attorneys in your firm or wherever you work. Rule 5.1 is on this website. And I think everyone struggles with that during this whole COVID-19, both people who work for the government, people in private practice. People are using Zoom and emails more, but it still is very, very important that you have constant communication with the people who you're working with on specific matters, making sure you know what people under you are doing and making sure that any deadlines are missed. I know. Gwen, what do you think from your point of view?
I agree, and certainly I invented a fact that is not in this hypo when I was responding with regard to the, you've committed malpractice and you need to notify your insurer, because I'm thinking of it as a jurisdictional deadline, and that would be the end of it. But if it isn't a jurisdictional deadline, then certainly there are things that can perhaps be fixed. But absolutely, whatever your practice group is, there needs to be a system in place at all times, but especially during times like this, where there's communication between the team members. Who's responsible for this? Who's heading it up? And are you going to be notifying the group when the filing is done? Who's reviewing it before it happens? I have a lot of sympathy for an associate at a big firm who feels like he or she can't raise his or her hand and say, I'm overwhelmed, I have too much going on, I can't do this, because there's a lot of pressure to meet hours requirements and things like that, and I get it. But it's a lot better to raise your hand and say to the team, it's going to be hard for me to meet this deadline in light of everything that's going on in my personal life, than later to say, I missed the deadline and I revealed the client's social security number.
Right, agreed. And I would just add one more practice tip now when, with people having lots of calls, either on the phone or through whatever technology, it's important to, if it's something that's an important issue, try and take contemporaneous notes, document in email to yourself or in a memo to your file. If it's something you want to make sure that you have a documentation, and therefore if something goes wrong later on, you at least say, here is the discussion we had when we had this call.
One more question. I think this is probably fair for anybody on the panel to jump in on here, because all of you are supervisors in some capacity. But I think that Gwen and Matt raised a good point here about the responsibilities of supervising, the challenges that I think are real here in terms of not being present in each other's lives physically as we once were. Have any of you in the last few months developed practices that you think are helpful for maintaining the level of communication that is probably required? Any tips that you would offer to others? I think many of the practitioners out there listening are probably similarly situated in terms of having some supervisory responsibilities.
Yeah, I guess I have even though I work at a very large accounting firm, my specific group is pretty small, and so at least a couple of times a week in the morning at 8:30 or 9 a.m. we have a internal call amongst 5 or 6 of us where we talk about, for a half hour, what we have on the plate, what certain issues, who's doing what. So I think that's at least a good tip if you have time. Obviously everyone is very busy, but even if it's just once a week, having a call to make sure you catch up and know what's going on, I think that's very helpful.
We do the exact same thing. We do twice a week calls, checking in, and literally go down the list and talk about every single case.
Great. Shall we move on to the next one here? In this second hypothetical, I'm sorry, Matt, did you have something else you wanted to? Okay.
Oh, no,
sorry.
Can move to Hypo too.
Sorry, thank you. So moving on here, hopefully this is also not too far-fetched, but we have a practitioner who is finding it difficult to stay connected to his firm's system in the normal course, and so just kind of as a workaround finds a way to keep pushing through and getting the work done, of course, but realizes a little bit later that some things have been going on without his knowledge, it would seem, that have led to a rather significant breach of the security that I think he otherwise thought may have been in place, or maybe he knew, but anyway, so finding that his son is 6 pages into a confidential memorandum, what should this practitioner do next?
And I'll start on this one, right? So I think the initial takeaway that I get when I read this hypo is that, at least for me, a very hard and fast rule is never save client information or data or anything confidential to your home computer. Working at the IRS previously, that sort of is ingrained into you, obviously because of 6103 concerns, but even then being on the outside, I know that the 2 accounting firms that I worked for are very sensitive about having client data stored on your own personal information. So that's just a key takeaway. There's Rule 1.6, which I think was on one of the other slides, talks about making reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. The ABA has put out a number of recent documents over the years that are very helpful to help inform practitioners as to what steps you need to take from an ethical perspective. We have a ABA Standing Committee Formal Opinion 477R, and it just talks about a greater risk of cyber theft in today's technology, which I'm sure Kathy can talk about in great detail, but it talks about certain steps that lawyers should take to guard against disclosures, including understanding the nature of the threat, understand how client confidential information is transmitted and where it's stored, understand and use reasonable electronic security measures, determine how electronic communications about client matters should be protected, label client confidential information, and then train lawyers and non-lawyers assisting in technology and information security, and then conduct due diligence on vendors providing communication technology. So I think all of those are very helpful tips and would have helped this practitioner. And then ABA Formal Opinion 483 talks about ethical duties following an electronic data breach or cyber attack, including Rule 1.4, duty to inform client. And really the conclusion in that formal opinion is that even though lawyers who make reasonable efforts to prevent the unauthorized disclosure and stay abreast of changes in technology, they still may suffer a data breach. And when they do, they have an affirmative duty to notify clients of the data breach in sufficient detail to keep the clients reasonably informed, and then talk about how to stop the data breach. So I think with this hypothetical, the practitioner's first step is really need to try and stop the data breach and figure out how he's going to fix it going forward, and then also notify the client depending on how significant the level of breach. Here, it may not be so significant if it's just the son, but it still is something you need to talk to the client, talk to your malpractice insurer about. And then obviously, if there was identity theft breach or something else, then you might need to get criminal investigation or someone else involved, certain other law enforcement, just depending on how significant it is. And
yes, and this is Kathy. I was exactly going to follow up with that.
Sure.
Is that please, if there's something significant, if it's not, hopefully it's not any one of you on the line, but maybe one of your clients who had a data breach, of course you need to notify the customers of that client, but in order for us to fix it, we need to know it as soon as possible and kind of shut it down and trace the funds, if there were any funds given, or trace the PII that was stolen. So please inform law enforcement as quickly as possible as well.
Right, and I know a couple of years ago there was a big, I mean, maybe it's still ongoing, I haven't heard it as much, but a couple of years ago there was a lot of identity theft where people were trying to get, they were doing snooping, where they would get information about all the employees at companies, including all their social security numbers, and then they would steal that from the companies. And I know CI was a big help in that context, so just keep that in mind. And then Rule 5.3 is talking about using non-lawyers for document managed company and internet-based service. So obviously you're allowed to do that in today's day and age, but you just have to make sure that you're hiring a reputable firm, doing your own due diligence, making sure there's procedures in place. And then the last thing I wanted to mention on this Hypo is there also have been some very recent state opinions that talk about issues related to virtual law offices and responsibilities in implementing third-party technology services. And the one that I really wanted to draw everyone's attention to was this Pennsylvania Formal Opinion 2020-300, because that was actually released April 10th of 2020 in response to COVID-19. And so it's a very useful document in talking about responsibilities in maintaining a virtual law office outside of your current office, and talking about the duties in that context. So I would recommend taking a look at that if you have any questions. And then also there might be other applicable substantive notification requirements, such as HIPAA, or if if health information of your clients is disclosed, or Graham Leach Bliley. So again, there's a lot of things that people need to be aware of. I don't know, Gwen, if you think anything else on this, or if we want to turn to Hypo 3.
So Matt, this is Pam. I just wanted to jump in and again talk about, or just mention again, the supervisor's responsibilities, and to make sure that the people that you supervise are aware of the requirements for maintaining this, making sure that there are no disclosures. So setting up protocols in your office for how information will be transmitted and maintained in this environment is also important.
Thanks, Ann. That's an excellent point. So let's move on then to the last of the prepared hypos for everybody today. And again, I think a sympathetic situation here, also probably not too unusual, unfortunately. And at the end of the day, of course, the practitioner would love to find a way to help his tenant and friend and neighbor here. So what assistance, if any, can the practitioner provide in this situation? And what are the limitations on the things that she can do?
This is Gwen. I'll start. The Hypo provides that the tenant and potential client has an issue where there's possible merit to a refund suit, but there's also an issue on another position that may have been fraudulent. And we don't say it in here, but I think let's assume for purposes of this discussion that it's in the same tax year. I, as a practitioner, am not going to get involved in this case. The taxpayer can't possibly try to claim a refund for a year in which there's fraud. And I think we can assume for purposes of talking through these ethical issues that if it was fraudulent, the practitioner can't take it because you can't submit a claim for refund knowing that you are exposing the client to potential fraud charges for trying to get money back, and you as a practitioner also cannot sign a claim for refund and submit a claim for refund if there's an offset to the rightful claim based on fraudulent either deductions or omission of income or whatever the source of the fraud may be. And so I do think if this person winds up becoming your client and you advise them not to file a claim for refund because doing so, first of all, you can't represent them in doing it, and secondly, they will be committing perjury for the second time by filing a claim for refund when there is, in fact, no merit to the claim. If you don't represent them, then perhaps you could help financially in matters unrelated to tax, but I don't see how you could give that advice without actually representing them. And so from my perspective, this is not a gray question. If you've got a client who, even if that client is indigent and even if there's a lot of merit to the claim, there's no basis for filing a claim for refund if part of that same tax year has either omitted income or overly generous expenses that the taxpayer is not actually entitled to. The refund absolute claim should not be filed, and certainly no practitioner should sign their name to it, and the taxpayer should be made aware of the potential criminal and civil ramifications of filing that claim for refund to begin with. But in terms of the question of can lawyers give financial assistance to clients, I think there are ways that we can direct clients to community services to try to help them, but certainly lawyers cannot provide direct financial assistance except to pay court costs, and Rule 1.8E is directly on point here. Other expenses directly related to litigation, but can't fund the past due tax in order to fund the claim, especially because the claim is not meritorious. Matt, do you have anything you want to add to that?
Yeah, no, I agree. If it was a different situation where maybe it was a different year or something, obviously there's very specific standards in the code in 6694 about signing tax returns in Circle 230, Section 10.34, and then obviously, like Gwen said, you have to file meritorious claims, and then even for taxpayers, right? There's rules about civil penalties for erroneous refund claims, even civil penalties, and then the only other thing I would mention is, you always have to worry about conflicts. If you're a tenant, is there any potential conflict in this? Dealing with this, and Gwen mentioned about advancing court costs, and that's in Rule 1.8E.
And if I fight the hypothetical a little bit here, or just kind of twist it a little bit, what if the practitioner here was able to refer the client, or the tenant to another attorney who, of course, was not the landlord in the situation? Could the landlord then be in a position to essentially give a little rent break so that suit could go forward? Or maybe it's a harder question. Maybe is it a gray area or no more gray?
If the practitioner is not representing the client in any way, shape, or form, and the client is represented by someone else, and the practitioner is the landlord, I think there is a possible rent break, but it couldn't ethically, to my mind, it could not be tied to the refund claim because the practitioner has some sort of stake in the refund claim that he or she knows to be invalid.
Yeah, I guess I
think that makes perfect sense.
I think, yeah, you always want to walk, be carefully in this type of stuff, whenever you're doing contingent fees or any kind of financial assistance with clients, and talk to your own, whoever you need to talk to make sure it's within the rules, just because you don't want to have any foot faults.
Great. So at this point, we'll open everything up to the floor for questions. And as questions come in here, I'll just try and get us started here with a question. And this is for anybody, but Gwen, you made a point earlier about making sure that you really have the capacity and confidence to take on new work. And obviously there's been quite a bit of work in the short term here related to the CARES Act. Do you have any suggestions or pointers to anybody, in assessing whether they're confident to take on that kind of work?
That's a great question. I can speak to what I personally do, which is I think to myself, if everything that I have in my docket blew up at the same time, would I be able to handle it? Do I have the capacity to handle it? And if the answer is no, not even close, or if the answer is yes, if I'm able to draw on X, Y, and Z resources, then I'll reach out and see if those resources are able to be marshaled. It's different depending on where you are. Certainly if you're at a large law firm, resources can be marshaled quickly, even if your group is small. If you're at or a large accounting firm, at a place like, for example, Castellanets and Fink, you have a lot of lawyers with a lot of expertise, and people can really dig in. At my firm, we only do one thing, and we're small. But I have other resources that I can draw on if I need to. And so it's a conversation that I have with clients at the initial engagement discussion about what they can expect from me, what I can expect from them, what I need to expect from them, and what the commitment, what I anticipate the time commitment will be, and that if it reaches a bigger commitment, at that point, then I'm going to have to start turning down other work. And so we have to talk about that. And that has happened where I get to the point where I say I'm not able to take on any more work, and have a discussion with the client who I'm dedicating significant amounts of time to within the firm, that in light of that, the retainer is going to increase, things like that. And that's just part of experience in managing caseloads and how things are going to flow.
Yeah, and I think anytime, right, a lot of tax practitioners have dealt with this a lot in the last 3 years with the passage of TCJA. There's a lot of completely new law that people need to get up to speed on very quickly, a lot of new IRS guidance that's coming out. Some of the regulation packages were hundreds of pages, right? So question of how do you read those, make sure, if clients are asking you questions on those new rules, you want to make sure that you are able to at least read the guidance. With the CARES Act that came out in March, a lot of the unpublished guidance, but then as we mentioned earlier, there's a ton of information on irs.gov. I would just give another shout out to the frequently asked questions on irs.gov, specifically in the NOL carryback situation, and in a lot of the other CARES Act situations. There's a whole bunch of frequently asked questions which are not binding guidance on the IRS, but they do provide a lot of helpful information. So you want to make sure you're looking at all different resources, reading, the tax press to the extent you can, and it's all a lot, right? It's hard to do everything, but you just want to do the best you can and try and make sure you're trying to be as competent as you can be on issues you're dealing with.
Meanwhile, you need to learn how to program your computer to, save things safely, right? Whatever computer language that is. No, I'm kidding, of course. I got a question here. If I'm not cutting anybody off, I've got a question here that I think is probably directed best in the first instance to Kathy. Kathy, related to the PPP loans, will the IRS be investigating anybody who timely returned a loan? I think it was May 18th or 14th was the deadline to return loans. Let's assume somebody did. What can they expect?
Great question. And so, yes, if an individual business or whoever asked for a PPP loan, received the funds, and then made the determination they did not need those funds for one reason or another, there was a safe harbor until May 14th, where they could return the funds with pretty much no questions asked. After May 14th, then it gets a little bit more tricky. In regards to, again, this is an SBA focused program and not necessarily an IRS focused program here that we're talking about, but if the funds were returned later, I don't think in the criminal aspects, the jury appeal would be very great to bring charges against an individual who might have taken out a loan in the beginning and making sure they're careful with their business and then ending up returning it, even if it's after the safe harbor has concluded. And so in my honest opinion, and only my opinion, is that I don't know if we would be going to further on that particular case for those individuals who are returning the funds. Now, if the person got the funds on a falsified type of manner, we contacted them, questioned them about it, and then they decided to return the funds, that's quite a different scenario because it was only until a law enforcement officer made contact with them did they choose to change their mind. So obviously case-by-case basis, but in your initial question, I would say that it's less likely that we would go after somebody returning the funds even after safe harbor is concluded.
Thanks, Kathy. And I suppose this seems to be something of a parallel in the situation you just described with filing a return that's false and then submitting a second return that at least attempts to resolve the original problem in the return. Maybe Gwen or Matt have some thoughts on I guess how that situation might be an analog here.
Yeah,
Gwen,
so I, in general, if you have somebody who has had to come to Jesus and they want to come in and disclose, the way to do that is to evaluate whether this is the person who should be coming in through the voluntary disclosure practice, which is no longer the voluntary disclosure program. And there's been a lot of discussion amongst practitioners that the voluntary disclosure practice, unlike the voluntary disclosure program, does not have as much of an assurance that the government will not seek criminal prosecution for someone who comes in and files an amended return and truthfully discloses past errors and omissions. But certainly it is our understanding, and Kathy, correct me if I'm wrong, that the government will not be pursuing those as criminal cases, assuming that the voluntary disclosure is timely and truthful and complete.
Yes, generically, I would agree.
And like Gwen said, there's a lot of different options depending on what's going on. There's obviously the voluntary disclosure program. There's Streamline if you don't think it's willful. There's delinquent international information return, delinquent FBAR program. So it really depends on the facts. But my advice would be, as I work at a law firm, so I technically, I work in an accounting firm, so I don't technically practice law. So you should talk to, if you are not a competent tax practitioner who works in this area, refer them to someone like Gwen, who deals with this issue a lot, who can help the clients solve it in a beneficial manner.
Great. So I think we have time for probably one more question here, and I think I'm going to ask about an issue that I think all of us are going to be dealing with increasing frequency as time goes on here, and that is if you have any pointers on how to deal with remote I'll say remote hearings, but I'd like to broaden it probably more to just any sort of court type function, whether it's a conference or a hearing, especially an evidentiary hearing or even a deposition that is going to be conducted remotely. I think that there may be some ethical concerns that come to mind in that context, but maybe of more immediate interest is just kind of how do we get through this in the short term. So I guess, Judge Buch, if you have some initial thoughts, then maybe we can get everybody else to weigh in on that.
Sure. I think there are a few things. One, planning in advance is critical for all parties involved. So not only the two sides communicating with each other, but communicating with the court. I've done several trials, for example, where I've had all electronic exhibits, and getting exhibits marked and electronically available to all of the parties in advance of the trial. Even if it's something that is not stipulated to, you still need things marked in advance so that they can be readily available and readily accessible to everyone involved. If you're doing a remote hearing, and again, I haven't done a complete remote trial to date, but I've had lots of instances where there are witnesses who are appearing remotely. Again, it's a planning issue of how do you make sure that you have the exhibits available to all of the witnesses who might be appearing remotely. And so I think the key thing really is communicating with the two sides, communicating with each other, but also communicating with the court. The vast majority of the judges, if not all of the judges, are happy to have conference calls to help iron out some of these kinds of issues. A question I think was one of the online questions earlier was sort of how exactly is Zoom going to work? Well, the answer is, contact the judge you're working with, communicate with the judge, and the finer points have to be ironed out on a case-by-case basis. And so I would say those are the key things when you get into issues of how are we going to deal with impeachment exhibits? If there's the potential for impeachment exhibits, there are ways to deal with that. In most cases, we don't have to worry about that. But if there are impeachment exhibits, then again, communicate with the judge, work out a plan for dealing with that. And again, those are all instances that many of us have dealt with before, and the collective experience of the judges on the court. These are the kinds of questions we share with each other. So the sooner you bring the judge into the process, we can help folks navigate through it.
Yeah, and I would just add, I think it's on this last slide, but I think Judge Buch said it. Communication is key, and that goes for almost everything we talked about today. So I think that's a good finishing point.
Okay, great. Thank you very much. That is all the time we have today. But before we leave, I will ask everybody who wants CLE credit to stay connected for instructions to get your CLE certificate. Also, please wait for the evaluation to come up on your screen. To our panelists today, thank you so much for sharing your expertise with us. On behalf of the ABA, I'm Nick Bonson, thanking all of you for joining us. I will now turn you back over to our operator for some additional information. Bye.
Thank you. On behalf of the American Bar Association and the ABA section of taxation, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at www.americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.